Hello and welcome to the Minimum Competence episode for Tuesday, March 25th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have SCOTUS hearing Louisiana's redistricting case, a judge slamming Trump's deportations, DOJ targeting law firms that dared to challenge the administration, and my column on state corporate tax sharing agreements. Let's remember, be sure you put your feet in the right place and then stand firm, and read today's legal news. On this day in legal history, March 25th, 1931, 9 black teenagers were arrested in Paint Rock, Alabama, accused of raping 2 white women aboard a freight train. The arrest set off one of the most infamous legal sagas of the 20th century, exposing the deep racial injustices of the Jim Crow South. The teens, later known as the Scottsboro Boys, were quickly indicted and tried in Scottsboro, Alabama. Just 12 days after their arrest, an all-white jury sentenced most of them to death in a series of rushed, chaotic trials marked by inadequate legal representation. Public outrage and national attention, particularly from black communities and civil rights organizations, led to multiple appeals. In Powell v. Alabama in 1932, the U.S. Supreme Court ruled that the defendant's right to counsel had been violated, setting a precedent that effective legal representation is essential in capital cases. Later, in Norris v. Alabama in 1935, the court found that the systematic exclusion of black jurors violated the Equal Protection Clause of the 14th Amendment. Despite these victories, the road to justice was long and uneven. Several of the Scottsboro Boys remained imprisoned for years, and none received a full measure of legal vindication during their lifetimes. Their ordeal became a powerful symbol of the racial bias embedded in the American legal system and spurred greater attention to the rights of defendants in criminal trials. The legacy of the case continues to influence debates over due process, racial discrimination, and criminal justice reform. At a U.S. Appeals Court hearing on March 24, 2025, that's yesterday, Circuit Judge Patricia Millett sharply criticized the Trump administration's deportation of Venezuelan migrants, suggesting they were given fewer rights than Nazis who were removed under the same legal authority during World War II. The administration invoked the 1798 Alien Enemies Act, a rarely used law last applied to intern Axis nationals during World War II, to justify deporting alleged members of the Venezuelan gang Tren de Aragua without immigration court rulings. The court is reviewing whether a temporary ban issued by Judge James Boasberg on such deportations should remain in place. Government attorneys argued that national security and executive authority over foreign affairs justify bypassing normal legal procedures. Family members and lawyers for deportees contest the gang allegations, saying they are based on flimsy evidence like tattoos. One deported man was a professional soccer coach whose tattoo referred to Real Madrid. Judge Millett questioned whether the deported migrants had any opportunity to dispute the gang labels before removal, calling the process rushed and opaque. The deportations carried out on March 15th sent over 200 people to El Salvador, where they are being held in a high-security prison under a U.S.-funded deal. The ACLU claims the administration defied Boasberg's court order by speeding up removals to preempt judicial intervention. The government has since invoked the state secrets privilege to avoid disclosing further flight details. The case is now a flashpoint over presidential power, immigration enforcement, and judicial oversight, with the Supreme Court Chief Justice issuing a rare rebuke after Trump called for Boasberg's impeachment. Yesterday, the U.S. Supreme Court heard arguments over Louisiana's congressional map, which increased the number of black majority districts from 1 to 2. The case pits efforts to comply with the Voting Rights Act against claims that the new map violates the 14th Amendment's Equal Protection Clause by relying too heavily on race. Louisiana officials defended the map, saying it was drawn to protect Republican incumbents rather than based on racial motives. They argued the redistricting was politically, not racially driven, particularly to preserve the districts of House Speaker Mike Johnson and Majority Leader Steve Scalise. Civil rights groups and black voters countered that the map was a necessary remedy after a 2022 ruling found the prior version likely violated the Voting Rights Act by diluting black voting strength. A 2024 lower court ruling blocked the updated map, saying race predominated in its design. The Supreme Court justices appeared divided, with liberal Justice Sotomayor skeptical that race had dominated the redistricting process, and conservative Chief Justice Roberts pointing to the odd shape of the second black majority district as potential evidence of racial gerrymandering. Justice Gorsuch challenged whether any consideration of race in map drawing runs afoul of constitutional protections. The court had previously allowed the new map to be used for the 2024 elections, but a final ruling is expected by June. The outcome could have broad implications for how states navigate the tension between addressing historic racial discrimination in voting and avoiding unconstitutional race-based districting. The Justice Department, under President Trump's direction, has launched an immediate review of law firms that have challenged his administration in court, wielding Rule 11 as a tool to pursue sanctions for allegedly frivolous litigation. The memo, issued March 21st, empowers Attorney General Pam Bondi to target lawyers not just for recent cases, but for conduct going back 8 years, reviving a rarely enforced mechanism that requires legal filings to be non-frivolous and not made for improper purposes. While legal experts note that courts are typically cautious about imposing Rule 11 sanctions, the administration's move is seen as a political shot across the bow of the legal profession. Trump has already threatened prominent firms with revoked security clearances and canceled federal contracts, but one firm, Paul Weiss, avoided penalties by agreeing to a $40 million pro bono commitment to Trump-aligned causes and an audit of its diversity programs. That deal, far from resolving the issue, may have signaled that capitulation invites more pressure. As anyone who's dealt with a bully could have predicted, surrender doesn't end the harassment, it encourages it. The only way to improve your position is to raise the cost of targeting you. Yet many law firm leaders and institutions of higher education, if we're being fair, seem to have missed that lesson the first time they encountered it on the schoolyard. Now, those same leaders face the possibility of serious professional consequences for doing exactly what lawyers are supposed to do: advocate for clients and challenge government overreach. Trump's order also singles out individuals like Democratic elections attorney Mark Elias, whom the memo connects to the long-disputed Steele dossier, despite no formal wrongdoing. Critics warn that the DOJ's probe could evolve into a tool to intimidate or sideline legal opposition to Trump, reshaping the legal landscape by discouraging firms from representing those who stand against the administration. Legal scholars have labeled the move a dangerous politicization of Rule 11, pointing out that it essentially makes Bondi the judge and Trump the executioner. In weaponizing a procedural rule with ambiguous standards and rare enforcement, the administration isn't just threatening lawsuits, it's undermining the adversarial system that keeps government power in check. And in my column this week, I talk about municipal corporate tax sharing agreements. California's new disclosure law on municipal corporate tax sharing agreements is a welcome move towards transparency, but it's not enough to stop the ongoing drain of public revenue. For years, corporations have exploited the split in California's sales tax, where 1.25% goes to local jurisdictions, by striking deals with cities that offer kickbacks in exchange for routing sales through their borders. This has created a race to the bottom, with municipalities, especially smaller ones, effectively subsidizing some of the world's richest companies in hopes of boosting their own budgets. These deals don't create new economic activity, they just reshuffle where sales are counted and where tax dollars land. While the new law will finally shine a light on these practices starting in April, disclosure without action won't solve the problem. Cities will still have incentives to offer generous tax rebates, and many will rush to lock in long-term deals before limits are imposed. What we need is immediate legislative action to cap how much of their tax base cities can give away. A ceiling tied to a city's budget or economic profile would prevent reckless giveaways while preserving flexibility for true economic development. We should also require that any shared tax revenue be reinvested in local infrastructure or services, not handed over as corporate windfalls. Waiting for more data only gives cover to continue harmful deals that are already draining school, safety, and infrastructure funding. Policymakers don't need years of reports, they need the courage to stop the bleeding now. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in an email, newsletter form. And we'll see you back here tomorrow. And until then, remember, in matters of style, swim with the current. In matters of principle, stand like a rock.